Hello everybody, Dr. Stringer here back. We're on to Module 5. We are talking about prosecutors this week. And so this week you had in your book, you didn't even have a whole chapter to read because half of the chapter in this, what is it we're on here? No, not chapter 5. Well, it's just section 3. Okay, well, we'll work with that. Well, this section, or chapter, or whatever your textbook wants to call it, is on prosecutors and defense attorneys. So since we're just talking about prosecutors this week, you just have to read that short section that's on prosecutors, and then those readings at the end of the chapter, which was Heather Schoenfeld and yeah. I'm going to try to pronounce it, but I don't even want to try. Anyway, and O'Neill. So you guys can read those. That's always in your syllabus, written in there in the schedule at the end of what you're supposed to be reading each week. So I hope that you're doing so before you take your exams and write your discussion boards, because that will be helpful. So anyway, we'll talk about the defense attorneys, which come up later on in the chapter in another module, so we're just having a short module to talk about these things. And so when we talk about prosecutors and defense attorneys and kind of the criminal justice system in general anyway, it's really made to be kind of this adversarial system where you have two parties, one representing the defense and one representing the prosecution, that are supposed to kind of argue against each other and work against each other in the pursuit of truth. And the argument being that if one person is advocating for this side and the other one for that side, that the truth should be able to be found somewhere in the middle, right? It's important to remember, you guys probably know this from previous classes, and maybe you've seen it on TV, that the prosecutor bears the burden of proving guilt of the defendant beyond a reasonable doubt. There is no burden of proof on the defense. It is the prosecutor that must prove these things beyond a reasonable doubt. And so, like I said, there's kind of this issue about, the real, adversarialness of the system, I guess. And so, is the system really adversarial? Some people say yes, some people say, well, maybe, maybe not. So the two theories kind of go to look into this. The first being this truth-finding idea, which is about the adversarial system. But then, given the fact that, we have so many plea bargains and so much of this is, taken out of the actual courtroom and doesn't really involve a trial, we really end up with kind of this model that kind of goes at whether we just kind of reach a fair decision when someone pleads, and then, a lot of times if you plead guilty to something, you will get a lesser sentence, or maybe even a lesser charge if you plead guilty to it compared to going to trial. And we'll talk about that when we talk about, or throughout this little short talk that we have here today. So the idea that, I think I've talked about at some point in time, that the prosecution and the defense are not really usually mortal enemies. Sometimes they're friends, a lot of times at the very least they are kind of acquaintances. There are some that do hate each other, that is true, but they're all members of the Bar Association, so they'll oftentimes, all the lawyers, the prosecutors, the judges all go to these Bar Association meetings and things like that, where they communicate with one another, and so oftentimes they are friends. And I talked a little bit about before how they're all part of this courtroom community or courtroom work group, so they all work together day in and day out, and so they do a lot of cooperation and negotiation between themselves, and there's a lot more of that than I think there is actual conflict, which you would think about within the adversarial system. I've kind of talked about, to some extent, the idea that the prosecutor has a lot of discretion. They decide who will be charged, they will decide what charge will be filed, they decide whether someone can be offered a plea bargain, and the type of the plea bargain that they can be offered. Now, sometimes the defense attorney might ask, well, would you be willing to accept a plea of this or that or the other? But the prosecutor has the option to say no. The prosecutor, and this creates a lot of tension between police officers sometimes, because police officers will arrest people, but not always does the prosecutor decide to prosecute those people that the police have arrested. And so, in case you can't imagine, that would create a little bit of tension from the police, who have gone and found someone to arrest, and then the prosecutor, for whatever reason, has decided not to go forward with the prosecution. Usually this will be because there is not enough evidence, and there's other factors that go into that as well, which is one of the reasons why police officers like to solicit confessions from people, because very rarely does a prosecutor decline to prosecute something where the person has written out a confession to the crime. That doesn't really happen very much. So there's something called strategic prosecution. Prosecutors really want to be successful in their careers. And so inattention is this idea of shifting prosecutors' attention away from individual cases brought to them by the police to an overall strategy geared towards reducing crime. And so they like to try to do that. They also want to make themselves look good. So they don't want to try to prosecute cases that they don't think that they can win, because then their conviction rate goes down much lower, which is what they are usually judged by, their conviction rate. So it's an important thing to think about as the prosecutor decides what he wants to do. So anyway, the harder side of the prosecution, the prosecution moves forward regardless of the victim's wishes. This is, one of those things that people don't really always think about, but it actually is very true. The prosecution does not represent the victim. They represent the state. And so just because the victim doesn't want to prosecute a crime doesn't mean that the prosecutor will abide by their wishes. Now, in domestic violence cases, this is especially true because, a lot of times the victim doesn't want to prosecute her husband or his husband or vice versa, whatever the victim and offender relationship may be, but the state decides to do so anyway. Now, this can be very challenging for the state to do when the victim doesn't want to testify. And so that can be a challenge. And so, these no-drop prosecution policies, looking at, domestic violence cases, you're seeing it a lot with drunk driving cases nowadays too, where there's a lot of political pressure and maybe even policies that come down from the district attorney saying that you are not giving you discretion in these cases, that you have to prosecute them. But then again, is it really worth prosecuting cases that aren't going to be won? Well, that's the question there that I kind of have. Is limiting discretion a good idea? And I think that it might be an exercise in kind of a frivolous action if you don't have enough evidence. But as we'll talk about, there's a lot of other things that go into prosecutors' minds when they're deciding whether they want to prosecute something, which may not be necessarily related to the strength of the case. So to think about, looking at, is this policy effective? Would it be effective to limit discretion? Would it be effective to have guilty verdicts and the number of cases going to court increased? Because that's what's probably going to happen, right? If you don't have any discretion, you're going to have a lot more cases in court. Prosecutors are going to be worked a lot more, right? Victims might be less inclined to call the police because they know that if they do call the police, it's going to be the offender's going to be arrested, they're going to be prosecuted, and there will be no way to get out of it. So the big things with plea bargains, the prosecutors have a lot of discretion here. One of the biggest things that it saves everybody a lot of time. One theory is that if there's an excessive caseload, being that prosecutors have tons of cases, that they'd be more likely to plea bargain things. And that might be true to some extent, but there are some studies out there that look at area or courts that have high caseloads and low caseloads, and they don't really find any difference in whether or not the prosecutors are plea bargaining these cases. I think by and large they just choose to do that rather than go to trial, because it's just easier and less time consuming, regardless of what your time constraints are. And that gets at kind of this easy care processing, right? We're just kind of moving cases through the process fairly efficiently without a whole lot of formal trial procedures going on. And so, sometimes we don't really take some cases seriously. Some petty things, like if someone was arrested for possession of marijuana, does the prosecutor or the defense attorney really want to spend a lot of time, prosecuting and going to trial for something like this? Why don't we just have a plea and, deal with it that way? And to a large extent, plea bargaining is kind of expected to some extent nowadays. I have heard of cases where defense attorneys try to approach prosecutors about pleas, and they won't even talk to them about it, which is very rare, but I have seen it happen, and it usually involves some sort of political issues going on or something like that, and so, but by and large, the plea bargains occur much more often than trials. So the two studies here, both Smith and Umber and Bradley, they've got a couple of different findings, but the two key things from there is Smith finds that those that go to trial do not necessarily receive a harsher punishment, but then Umber and Bradley say that those that plead guilty and through a plea bargain usually do have a shorter sentence than those that go to trial. This is known as the trial penalty within the literature, and even the judges. If you think about it, it's in the interest of the prosecutor and the defense attorney to have a plea, but also when there's a trial, the judge is the one that also has to sit through all of this too, and so the judge might be less inclined to give a more lenient sentence to someone that makes him sit through a 4-hour trial versus someone who pleads guilty and admits that he's committed the offense and takes up half an hour of the judge's time. So the trial penalty is actually something to consider. Looking at I've talked a little bit about the two theories of the truth-finding adversarial process, but looking at kind of how plea bargains occur so frequently, this fair decision is probably more likely to be the types of processes that we see most often. This kind of negotiated justice, if you will, that kind of makes pleas where both parties are reasonably happy. The prosecution might not get the big conviction with a long sentence, but they don't have to do all the work of the trial, and vice versa. So the defendant might not get to go free, but he's not getting 10 years in jail. He's only getting 1 year or something like that. So there's been a few studies that have tried to look at controlling plea bargains. And so the first one there in Michigan, they found that banning plea bargains had little impact, that charges were adjusted anyway. And then in Alaska, plea bargains, banning plea bargains didn't have any impact there either. The defendant still pled guilty. This might have something to do with the fact that, they didn't want the judge to impose the trial penalty, like I said. But looking at California and McCoy in 1982, they found that getting rid of the plea bargains didn't really increase the sentence length, but it was associated with a large prison population increase, in case you can't imagine, because more people are getting put into prison, because more people are getting sentenced to prison versus perhaps alternative types of punishments, of probation and things like that, that they might have gotten when they were on, if they had a plea bargain. So there's no legislative or judicial guidelines for charging. And the decision not to file charges ordinarily is immune from review. Now, That doesn't mean that if the prosecutor decides not to file charges, he can't then change his mind 6 months later and decide to file charges. There is nothing that prevents that from happening. And in some instances, an assistant district attorney might decide not to file charges, but then perhaps through political pressure, the district attorney might decide, well, no, we can't seem tough on, or that we're not tough on crime. We need to prosecute this, and this needs to be, taken to the court. So that can actually happen. But in most prosecutors' offices, there's no real explicit criteria or concrete guidelines for prosecutors in deciding whether to charge people or not, which leads prosecutors to having a lot of discretion there. So why prosecutors might decide not to file charges? So the first one is, well, the prosecutor might believe that the suspect is not guilty of the crime that they're charged with. The second one might be that the prosecutor does believe that the person is guilty, but they don't have enough evidence to prove that. And they don't believe that they would be able to get a conviction. So they think that, they shouldn't really waste the court's time. And then some other researchers say that charging decisions are not simply a product of individuals exercising discretion, but rather departmental politics, things like that, that dictate how cases are evaluated. Like I said, the assistant district attorneys answer to the district attorney, who is usually an elected official who is, very much related to the politics of an area. So studies of the charging processes demonstrate that prosecutors exercise their discretion and reject a significant percentage of cases that they screen. They decide not to pursue them. A lot of times they'll tell the police, I'm not prosecuting this, but if you get some more evidence, come and see me, something like that. Most studies of the charging process also conclude that prosecutors attempt to avoid uncertainty. They don't like to try to file charges where the conviction is unlikely. They don't really like uncertainty. They'd rather focus on these cases where the charge is fairly certain to be upheld and the conviction is pretty certain, which to some extent makes sense. You don't want to go roll the dice when you've got other things you could be doing that are more certainly to be fruitful, especially if you're worried about your conviction rate. So there's things called legal and extra-legal factors in decisions. So there's legally irrelevant characteristics of the suspect and the victim. The relationship between the victim and the suspect, the lack of the motivation on the part of the prosecutor's office, the questionable wisdom of state intervention in family affairs, and then race and gender and other things actually play into this as well. And these would be considered to be extra-legal factors, right? They're not the legal factors. The legal factors would be, how much evidence do we have? Was the person at the crime scene? Things like this. Do we have witnesses? These are all the legal things that you would think about. Does this fact pattern of the evidence that we have fit whatever the law says for the offense that we're trying to prosecute the person for? And then there's this idea of focal concerns theory. We're going to talk about judges more later on in class. But judges' sentencing decisions tend to reflect this idea of the kind of the blameworthiness or the culpability of the offender. Now, this also would weigh into the prosecutor's decision as well. If the prosecutor sees this person as more culpable or more blameworthy, they might be more likely to prosecute them. They might also be more likely to not give them a very beneficial plea deal. They might say, well, I'm still prosecuting you for murder one, but I'll take the death penalty off the table or something like that. And this comes from the desire to protect the community by incapacitating dangerous offenders as well as deterring potential future offenders. And so concerns about practical consequences or social costs of sentencing decisions also matter too. One of the biggest challenges is, within the corrections literature is, you build a new wing onto the jail in order to ease the overcrowding because, you've got the jail is becoming overcrowded. And well, what happens is the judges know you've built a new wing. And so they're like, well, we're going to have to fill this new wing, even though they don't really think about the fact that, well, it was to ease the overcrowding. We don't really need help with filling it. We were trying to take some of the rooms that had 3 or 4 people in them and get them to their normal capacity, which was 2 people per cell. But, there's not really a whole lot that you can do when it comes to the judge's decisions to do things like that, especially if you're in charge of the jail. You can ask the judge maybe if you might put people on things. And this is another thing that happens too when we come up with things called intermittent sanctions, like developing new ankle monitoring systems and things like that. We can't really control who the judge puts on these things and who they don't. And so while they'll usually be designed to get people that would have gone to jail into the community supervision, what usually ends up happening is that doesn't happen. The people that were going to go to jail anyway, and then the people that would have just been put on regular unsupervised probation end up being the people that have the ankle monitors and the things like that, because they're considered to be a low risk. So you might devise these things to ease the prison or jail overcrowding, but it's in the ultimate judge's decision, which you don't really have a lot of control over who goes on these things. So went on a little tangent there, but professional standards of conduct apply to prosecutors. They are governed by the American Bar Association standards for not only, they also govern the defense attorneys and the judges too, but the prosecution function enjoys some especially important functions under the standards, and they're actually held to some extent to a higher standard than the defense attorneys are. But their standard of conduct is that there are reasonable doubt that if they have things such as a reasonable doubt that the accused is guilty, then is it ethical to prosecute this person? And these things, they should look at the harm caused by the offense, improper motives of the complainant, or reluctance of the complainant to testify, the cooperation of the accused in the apprehension or conviction of other offenders. And so you guys might have heard of these things like this before, where you have someone that you've caught, and then the prosecution has decided to give them immunity from prosecution and decided to not prosecute them in exchange for them giving testimony or helping them or giving them information so that then they could apprehend other people. You see this much more often with drug offenses, because usually the police will catch somebody with a little bit of marijuana or a little bit of cocaine or something like that, and what they really don't want to do is send you to jail for possession of cocaine or marijuana or whatever drug that you have, because you're just a small fish. What they really want you to do is to turn state's evidence and to become a witness against the person who sold it to you. And what they really want to do is get that person who sold it to you to turn and testify against the person that they got up. And the DEA is very good at working up this chain, so to speak, to be able to get to these upper levels. Because that's really the only way that we can really have any meaningful impact on drugs in society, is by getting at these people that are supplying them. By arresting the people that are just using them, you're not really going to have a lot of lasting impact, at least from a criminal justice standpoint. Your first article, I just want to go through these quickly and kind of give you an overview about them. In your Schoenfeld, I still don't know how to pronounce that woman's name. We'll call her Heather. Heather had this article, which is on conceptualizing prosecutorial conduct. And it talks about how prosecutors are agents of trust, how the public trusts them with the skills, the knowledge, and the power, most of all, to prosecute offenders. And so when they commit misconduct, this really violates this trust. And so the kind of the causes of the misconduct are usually this idea of neutralization. And it borrows a lot from Sykes and Matz's theory of techniques of neutralization. And that's, for them, it's kind of, they evaluate their motive and their opportunities in a way in such they've kind of neutralized these symbolic constraints which tell them that they're not supposed to do whatever unethical misconduct type of thing they're doing. And so a lot of these things the neutralizations occur because, to be honest with you all, the prosecutor is supposed to serve justice. He's not supposed to serve to seek convictions. They're supposed to serve justice. And so in a sense where conviction would not be just, or not serve justice, then the prosecutor is not supposed to pursue that sort of case. However, given the adversarial system, the prosecutors versus defense attorneys, prosecutors don't really think about themselves as trying to serve justice. They think about themselves as trying to secure convictions. And then there's a fine line between the legitimate and the illegitimate, or the misconduct. The article talks about one example of Batson versus Kentucky, where, in case you don't know, this is regarding the Batson challenge, or this is where the Batson challenges came from, to removing people using your peremptory challenges based upon race. And they openly admitted that, race was not the key factor that caused them to exclude those jurors, but they couldn't say that it wasn't a factor. And so then there's kind of this fine line in there. Batson says you can't make it the factor, but can it not be any factor? No. So there's kind of that fine line there. And then there's this assumption of guilt. We all talk about this wonderful process where you're assumed to be innocent until proven guilty, but those of you that have taken a good number of criminal justice courses, you're probably aware of the idea that by the time you get to the courtroom, especially if you're wearing an orange jumpsuit in the courtroom, you're assumed to be guilty. The jury assumes you're guilty, the prosecutor does, the judge does, everybody assumes that you're guilty, because if you weren't guilty, the police would not have brought you forth, the prosecutor wouldn't have prosecuted you, and it wouldn't have gotten this far. So you're kind of assumed to be guilty, and so prosecutors can use that to kind of help rationalize their behaviors as well. I'm prosecuting someone that's guilty, and I need to do this in order to get this conviction of this guilty person, so that this guilty person doesn't go free and rape, rob, or murder someone else in the community. And then it talks about another one of the issues about the different standards that defense attorneys versus prosecutors have, and prosecutors will say, well, if the defense attorneys are allowed to do this, then I should be allowed to do it too. And so that's their way of kind of neutralizing getting away with the thing that they're not supposed to be doing. And so the article goes into the different motivations and the opportunities and sanctions. I've kind of talked about big motivations is that they want to be good at their job, and one of the key ways that they're evaluated is based on convictions. This is how their raises and promotions and things like that will be evaluated. They also, as a prosecutor, you're supposed to be tough on crime, right? You don't want to be soft on crime and be a prosecutor. It's not the best position for you to be in. You're supposed to be the tough, hard, tough on the crime type of person as the prosecutor. And sometimes one of their motivations and issues that comes up is they tend to value punishment more over fairness. And so then that becomes an issue in there too that she talks about to some extent. And the opportunities for these things largely occur because of professional standards and because of the organizational structure and the way that everything is organized to allow prosecutors so much discretion. And then the sanctions for this discretion are so minimal that it ends up not being a very good deterrent. If you look at appellate review and reversal, the appeals courts have said, well, you can prove that there's misconduct, but if we find that this misconduct was harmless, under the harmless error doctrine, then we're not going to reverse it anyway. And then the professional sanctions and civil penalties and criminal prosecution is very rare, if it ever does occur as well. And one thing too being that prosecutors have immunity for what they do in the courtroom, and so it's very rare to see them be prosecuted either civilly or criminally. However, if they do something too bad unethically, they can be sanctioned by the bar, but this happens very rarely because you'd have to do it to such a blatant level that it got such attention and things like that there would be clear evidence of that. The one big example of that is the David Nifong in North Carolina, where he was running for re-election and he kept making all of these statements to the media about this case. And he was the district attorney. He wasn't an assistant district attorney. And he decided to prosecute this case to seem tough on crime and things like that. And he really politicized the case in the media, which you're not supposed to do. It's very unethical. And this ended up being a big problem for him. And I think I know that he got some sanctions from the bar. I don't remember if he got disbarred or what happened with him. I'll have to check on that and let you know later on in the class. But anyway, and so looking at the other article that talked about intimate partner violence, remember I told you guys that one of the biggest issues with reducing discretion for prosecutors and police officers as well has been regarding intimate partner violence, domestic violence and things like that, because there's such a reluctance of the victims to testify, and also these other issues that prevent police from wanting to make arrests and prosecutors from wanting to go forward with these things. And so this study looked at different legal and extra-legal factors that decide or that are related to whether prosecutors decided to prosecute these cases. And so the big four that they came up with was victim credibility, how credible they thought that the victim of this was. And then they also found some evidence of intimate partner rape myths. This kind of idea that, well, this is your intimate partner, so can they really rape you? And so they were seen as a less serious a crime. And for those of you that don't know, up until, I want to say about 100 years ago, it was considered impossible for you to rape your spouse, because it was thought that you had consented to having sexual intercourse with your spouse when you married them, and so it was an exception to the rape law that this could not occur because you were married. Now obviously that has changed significantly by now, and now you can actually be charged with raping your spouse, because this actually happens sometimes. Just because you're married to someone doesn't mean that you want to have sex with them, and so obviously if you decide you don't, and that doesn't mean that they can hold you down and do so, which is a very good evolution in the law that we've had. Another thing that they look at is the victim's alcohol use, and so this is not really very relevant, right? Why should the victim's alcohol use be related to whether or not you prosecute someone for raping them? And this is kind of this idea, it gets back at the kind of techniques of neutralization and this kind of ideal of denial of the victim. Well, actually that and the intimate partner rape myths do too, kind of denying that this person was victimized, and kind of this victim blaming idea, right? It's kind of like, oh, well, you wouldn't have been raped if you weren't drunk, or you weren't wearing that, high dress or something like that, and so these are issues when it comes to prosecutorial discretion, right? We shouldn't be basing whether we decide to prosecute someone for raping someone based upon the victim's alcohol use. And then there was domestic violence factors as well that you can read in there, where they found that if there was domestic violence, then it was more likely that the prosecutor would elect to prosecute that case versus if there was not any domestic violence that occurred, and then that would not be as likely to go forward. So I think that is all that I have for you all for this week, and hopefully you enjoy reading about prosecutors and reading all of the details of those things I've told you all about today. So I look forward to talking to you all next week, and everybody have a good week.